Paris, a law banning most abortions in Texas, took effect today with no action from the Supreme Court to block it. The law prohibits abortions after about 6 weeks of pregnancy, as soon as a heartbeat is detectable. What's more, it also allows private citizens to sue abortion providers and anyone else who helps someone get an abortion. Now, this has advocates questioning the future of Roe versus Wade, especially as the state of Mississippi is asking the Supreme Court to overturn the landmark ruling altogether. Joining us to talk about the impact of this law and the possible legal challenges ahead are Peter Breen, Vice President and Senior Counsel with the Thomas More Society, and Carolyn Shapiro, Professor of Law at Illinois Institute of Technology's Chicago-Kent College of Law. Welcome back to the both of you. Carolyn Shapiro, let's start with you, please. What is your reaction to the Supreme Court not ruling on this case?
Well, I think it's possible to see a lot of different outcomes, but it is not a good sign for those of us who believe in reproductive rights. It is entirely possible that the Supreme Court will yet stay this law, that what we're waiting for is, say, dissents from justices who don't agree with that step forward. But none of it really, that would not tell us anything about what the Supreme Court is going to do in the longer run with respect to Roe versus Wade. It has already been asked to overturn, directly been asked to overturn Roe versus Wade in this case out of Mississippi, that it will be hearing this term. So I think the court would probably prefer to be able to handle that question in the more sort of normal order, which would be by hearing that case, having the argument. But this case procedurally has sort of jumped the gun. And again, for those of us who believe in reproductive rights, it's not a good sign.
And we'll come back to that Mississippi case in just a bit. But Peter, what is your reaction to the Supreme Court not ruling on this case?
Well, it's the correct ruling as to this law, because this is a law that needs to be dealt with in the state courts in Texas, because it's a private party dispute. The way they drafted this was a uniquely drafted law to avoid a pre-enforcement challenge against state officials. So the law will be litigated. It just will be litigated in the Texas state courts. And of course, if the reproductive rights advocates get a negative result, they can go up to the U.S. Supreme Court. But hopefully by that time, you would have a decision in the case out of Mississippi. And really, the Texas legislators, in their short session, they do a short session once every 2 years. They may have thought, hey, we think that the Supreme Court is going to overturn this. And so they put this law into effect back in May, to be effective on, now, today.
So it's actually important to be clear about what's happening procedurally, because it's true that this law was designed to give private people the ability to sue anybody who either any doctor who provides an abortion that's prohibited, or any individual who, in the words of the law, aids or abets such abortion from to take place. Now, that's a very unusual situation where what we have is the state is outsourcing its violation of somebody's constitutional rights, because that is currently the law, that would violate women's constitutional rights, to private individuals, and creating an enormous incentive for them to do so by providing for a statutory bounty of $10,000 every time they win. So it's one thing to say, well, this will eventually get litigated in the state courts, but imagine if, for example, we had a similar law in Illinois that allowed me to sue anybody who refused to get vaccinated, or anybody who insisted on attending church services in a large group without a mask. I think we would see those as a really inappropriate delegation of state power to private citizens, and that is what's happening here with this law in Texas.
Peter Breen, do you think that particular part of this law, is it necessary that people have the option to sue someone in this instance?
Well, the problem is we do this in other contexts. And of course, the good professor is citing things that she thinks will inflame the right wing, I guess. But look, we call them private attorney general statutes. It happens all the time. So normally, though, in a private attorney general statute, you could have the attorney general enforce it or a private person. In this case, they're just using the private attorney general part of the statute. Again, it's the sort of thing, it's unique, certainly, but there's nothing inherently wrong with doing it. I mean, the real difficulty that we've found ourselves in was in 1973, the Supreme Court read a right to abortion into the federal Constitution, overturned the laws of nearly every state in the union. So that's really the problem. We've had this, the abortion distortion in the law has caused the need for legislatures to be creative in their legislating in this way. If the Supreme Court merely just puts the issue back to the states, then folks can just, legislate in a more normal way. But again, private attorney general statutes, we see those all the time.
So
Well,
we
we
brought up,
actually see those when people are injured, not when any individual can sue anybody that they have no connection to. So there are significant differences between the private attorney general laws and this one. And the reason that this law was written the way it was is, in fact, to make it difficult for it to be challenged. It was a very manipulative effort.
So I'm sure we can talk about that back and forth between the two of you for a while, but I do want to talk about this other legal battle that is brewing in Mississippi. Potential law would ban nearly all abortions after 15 weeks, and the state is also asking the court to overturn Roe versus Wade entirely. Peter, first, how do these laws stack up as far as laws that make abortion illegal after a certain amount of time?
Well, and this is something, we had started with 20-week bans on the pro-life side. We had trying to push that limit back from viability, which is somewhere in that 21, 22, 23 weeks, depending on medical technology. Try to pull those numbers down. Mississippi, they went to 15, and that was one that got challenged and up to the U.S. Supreme Court. The issue is, though, can a state limit pre-viability abortions? So that really does go at the whole Roe v. Wade line of precedent. And it's Roe v. Wade and Planned Parenthood v. Casey, et cetera. And so the laws are very differently written. They're very different in their, the way that they're enforced. But at its heart, I mean, the question presented by Texas is, can you ban abortions after a heartbeat? Mississippi, can you ban them after 15 weeks? The broader question is, can states actually regulate abortion pre-viability? And that's what we hope the Supreme Court will answer. And I'd like to see them answer it in the affirmative, because that was the law for most of the nation's history, and certainly it was our law prior to 1973.
And Carolyn Shapiro, based on what we've seen in abortion cases up to this point, including this one, and based on who we know is on the court, what is the likelihood that the court should overturn Roe versus Wade in 2021 in this term?
Well, I think that there are some justices who don't like Roe versus Wade, who would much prefer to chip away at it and maintain what they would consider to be plausible deniability, while in fact making it difficult or impossible for women throughout the country to get abortions, to have access to reproductive health care. But there are some other justices on the court, for example, Justice Thomas, who's been quite explicit that he would be delighted to overrule Roe versus Wade. I think Justice Alito would join him. The question really is whether the new justices on the court want to do something that is so clearly a switch related to change in personnel, overruling a really long-standing precedent that many people don't like, but that remains a long-standing precedent purely because there are new justices on the court, which is what it would look like. I don't think the Chief Justice would like to see Roe versus Wade overruled in that way, though I'm quite sure that he'd be happy, again, to chip away at it and make it difficult, if not impossible, for women to get abortions.
Okay, a complicated subject. We'll have to leave it there. I'm sure we'll discuss this again as we continue to watch the Supreme Court. Carolyn Shapiro and Peter Breen, thank you both for joining us.
Thank you, Brandis.
Thank you.